I think we can go ahead and get started and folks can continue to come in. But welcome everyone to today's presentation on protecting yourself and your farm, understanding workers' compensation in Maryland. So my name is Samantha Capaldo. I am a Senior Legal Research Associate with UMES Extension. And then on the slide is my contact information, and my contact information will be, again, at the end of the presentation. So first, we have a few acknowledgements and disclaimers to go over. So this is our funding acknowledgement. This is saying that the Workers' Compensation Guide was supported in part by the United States Department of Agriculture, National Institute of Food and Agriculture in partnership with the Maryland Legislature. So any opinions, findings, conclusions, or recommendations expressed in this work are those of the authors and should not be construed to represent any official USDA or US government determination or policy. So this is USDA and UMES Extension's non-discrimination statement. And then lastly, because I am an attorney, I have a general legal advice disclaimer. So this presentation is intended to provide general information and should not be construed as providing legal advice. It should not be cited or relied upon as legal authority. State laws vary, and any attempt made to discuss laws of states other than Maryland is for general information to help the viewer better understand Maryland law. For advice about how these issues might apply to your individual situation, please consult an attorney. So now that the disclaimers are over, we can get into the actual presentation. So workers' compensation is a type of insurance that compensates employees for lost wages and medical bills due to a work-related accidental injury or occupational disease. Workers' compensation in Maryland is governed by the Maryland Workers' Compensation Act, which was first passed in 1914 and has been amended several times since. I will be referring to this act throughout the presentation simply as the act. It's a mouthful to say Maryland Workers' Compensation Act every time. So the act outlines who is required to obtain workers' compensation, who is covered, what injuries are covered, what benefits are provided, the obligations of the employee and the employer in the event of a claim, the role of the Maryland Workers' Compensation Commission, and any penalties for violating the act. So this webinar will cover most of these areas. For any areas that you want more information on or that are not fully covered in this presentation, please consult the guide, and Nicole's going to drop links throughout the presentation to the guide itself. And then I have a QR code kind of towards the end of the presentation on where to find the guide. So first, who is required to have workers' compensation in Maryland? So under the Act, employers are required to purchase workers' compensation insurance if the employer has at least one covered employee. So a covered employee is defined in the Act as an individual that is in the service of an employer under an express or implied contract of apprenticeship or hire. So it's really about that relationship between the employee and the employer. This definition applies to full-time and part-time employees. So again, it's really the relationship that is important to determine whether workers' compensation is required, not whether that employee is full-time or part-time. So under Maryland law, minors and undocumented workers are covered employees if they meet, again, that relationship requirement, and they would be entitled to benefits in the event of an injury. Covered employees can also include sole proprietors if the sole proprietor elects to be covered. So for more information on kind of how that election works, we outline that in the guide. So the Maryland legislature did add an exemption from the state workers' compensation requirements for some agricultural employers. So agricultural employers do not have to provide workers' compensation to their employees if their annual payroll is less than $15,000 or the employer has less than 3 full-time employees. However, as most of you are probably aware, agriculture is an inherently dangerous field. So the U.S. Bureau of Labor Statistics releases data on fatal and non-fatal injuries across industries. In 2022, there were approximately 300 fatal injuries and 26,000 non-fatal injuries associated with crop and animal production throughout the United States. So because of this inherently dangerous nature, agricultural employers can provide and should consider providing workers' compensation to their employees, even if they are exempt. One thing I want to note is that there is not a clear definition of farmer under the agricultural exemption. And so if you have an operation or work with operations that you think may fit into this exemption, you should definitely consider talking to your attorney to determine how and if this exemption applies to your specific operation. So what are the benefits of workers' compensation? So workers' compensation protects a business and its owners by paying for claims by employees who experience a work-related injury, illness, or disease. And in exchange for this, the employee forfeits the right, in most cases, to sue the employer in court for damages related to that injury. Workers' compensation also protects the employees and their families by providing compensation to an injured employee for medical expenses, a portion of lost wages, rehabilitation costs, and funeral expenses. Additionally, the workers' compensation claims process is a more streamlined process than pursuing a negligence claim in court against your employer. Lastly, even if the employee is partially at fault, coverage will be provided in most situations. I am going to outline in the next slide when injuries are explicitly not covered. So, which injuries are covered? So, workers' compensation provides benefits for accidental personal injuries and occupational diseases that arise out of and in the course of employment. So, over the next couple slides, we're going to walk through each of these requirements. But there are a few injuries that are explicitly not covered, and those are injuries that occur because outside of the scope of employment, injuries that occur because the employee was under the influence of drugs and or alcohol, or injuries that are intentionally self-inflicted. None of those types of injuries would be covered under workers' compensation. So the first requirement is that the injury must be an accidental personal injury or an occupational disease. So to be considered an accidental personal injury, the injury must meet one of the three criteria listed on kind of the top half of this slide. So it must an accidental injury that arises out of and in the course of employment, an injury caused by a willful or negligent act of a third person directed against a covered employee in the course of the covered employee's employment, or a disease or infection that naturally results from an accidental injury that arises out of and in the course of employment. So let's talk about a couple of examples of each of these. So some common injuries that are associated with that first criteria would be injuries from farm machinery, employee falls, or an employee being kicked or bitten by livestock. An example of an injury that would meet the second criteria is in this following scenario. So an employer operates a Christmas tree farm that allows customers to come to the farm and purchase a tree. The employer directs a few employees to work in the area where customers are loading trees onto their cars. A customer is not paying attention when they're leaving the loading zone and they hit the employee with their car. Any injuries that result would likely be covered under this second prong of the accidental personal injury definition, and the employee would likely receive workers' compensation benefits. So that act of hitting the employee with their car would likely be seen as a negligent act of a third person. Under the third criteria, an example of an injury here would be if an employee is bitten by livestock and they then develop an infection from that bite. That would fit under that third criteria. So workers' compensation also provides coverage for occupational diseases, which are diseases that are contracted by a covered employee as the result of and in the course of employment, and that causes the covered employee to become temporarily or permanently, partially or totally incapacitated. So some examples here that could be seen in the agriculture space are asbestosis, skin cancer, chemical poisoning from exposure to pesticides, and heat stroke. So the second requirement is that the accident or occupational disease must arise out of and in the course of the employee's employment to be covered by workers' comp. So for an injury to occur out of the course of employment, the injury must have occurred because of the conditions required by the employer for doing the job. So if an employee is required to be working outside, slips on a wet or muddy surface, the employee would not have been injured but for the employer requiring that the employee work outside. So that's kind of an example of how that out of the course of employment works. So for an injury to occur in the course of employment, the injury must have occurred during the employee's working hours. So with agriculture, many injuries are associated with as a result of transportation incidents. So employees injured while traveling in a vehicle are generally compensated by workers' compensation if the travel is required by the employer and the employee is not on a personal errand. So think like a lunch break. However, the Maryland courts, through their case law, did develop an exception, and it's called the going and coming rule. So under the going and coming rule, injuries sustained by employees commuting to and from a fixed site of employment are generally not covered because these situations do not meet the definition of arising out of and in the course of employment. So if an employee is injured while traveling to work from their home or home from work, these wouldn't be covered because it's not during their working hours generally. The courts did develop an exception to the going and coming rule called the positional risk test. So essentially, this is an exception to the exception. So if an employee is traveling from a work-related activity to a site where they engage in a work-related act, the coming and going rule would not apply, and any injury that occurs would likely be covered by workers' compensation. So let's do another example. So an employer operates a beef cattle farm with broken fence posts. The manager sends 2 employees to a supply store to purchase new fence posts. And on the way back from the supply store, the employees are in a car accident and both sustain injuries. These employees would likely be compensated for their injuries under workers' compensation because the injury would not have occurred but for the employer requiring the employees to go to the supply store. So now let's move on to benefits. So workers' compensation provides multiple classes of benefits, including lost wages, medical bills, vocational rehabilitation, death benefits, and funeral expenses. So the amount of the wage benefits provided under workers' compensation depends on the duration and severity. So you've heard me refer once to temporary or permanent and partially or totally incapacitated, and the benefits depend on which one of those the injury fits into. So for example, if the covered employee is temporarily or permanently totally disabled, meaning for either a set period of time or for the rest of the employee's life, the employee cannot work at all, the employee is entitled to 2/3 of their average weekly wage. This average weekly wage, however, cannot exceed Maryland's average weekly wage, which is set by the state. And for 2025, it is $1,493, and it's set every year. So the duration of total benefits available to the employee does depend on the type of injury, the body part affected, and the severity of the injury. So now we're going to move on to obligations, both on the employer side and the employee side. So employers do have obligations to the Workers' Compensation Commission when an employee is injured. When an employee is injured on the job, their primary responsibility in the context of workers' compensation is to notify the Maryland Workers' Compensation Commission. So for accidental personal injuries, accident reports are required if the employee misses more than 3 days of work due to the injury, and these reports must be filed within 10 days of learning of the accident. For occupational diseases, the standard's a little bit different. So the accident report must be promptly filed upon the employer learning or being notified of the occupational disease. And this form can be submitted either by the employer directly or by the employer's workers' compensation insurance company. So the accident report must include whether the accidental personal injury or occupational disease arose out of and in the course of employment, the time, cause, and nature of the disability, and the accidental personal injury or occupational disease, the probable duration of the disability, and any other information that the commission may require through their regulations. The commission does have a form, and it addresses all of these items and does request some more information. And the commission has also provided an online portal to submit the accident report. It can also be submitted by paper using the form on their website. Because failing to notify the Workers' Compensation Commission within the required time frame can lead to fines. The Workers' Compensation Commission generally recommends that employers always file an accident report when an employee is injured, either at their place of business or while working, and then an investigation will occur to determine whether benefits will be provided. Just two things to note with the employer obligations. Employers are prohibited from deducting workers' compensation premium payments from the employee's salaries or wages. And employers are also prohibited from firing an employee solely for filing a workers' compensation claim. So now let's switch to employee obligations. And employees are a little bit different. They have obligations to the employer and the Workers' Compensation Commission. So the reporting requirements to the employee's employer do vary depending on whether the accidental personal injury or occupational disease results in death. So for accidental personal injuries that do not result in death, the injured employee must notify their employer either orally or in writing within 10 days of the injury. And then for occupational diseases that do not result in death, the employee must notify their employer within 1 year of when the employee knew or should have known that they suffered from that occupational disease. For accidental personal injuries that do result in death, the family of the employee must notify the employer within 30 days of the employee's death. And then for occupational diseases that do result in death, the family must notify the employer within 1 year. And I have all of those time frames laid out on the slide. And then there are also reporting requirements to the Workers' Compensation Commission. And these, again, vary depending on whether the injury or occupational disease results in death. So for most accidental personal injuries that do not result in death, the employee must file a claim form with the commission within 60 days of the injury. For accidental injuries that do result in death, the employee's family must file the claim form with the commission within 18 months of the employee's death. And then for most occupational diseases, whether the disease resulted in death or not, the injured employee or their family must file the claim form with the commission within 2 years. There is an additional year allowed for pulmonary dust disease. And in that case, the employee or their family have 3 years to file the claim with the claim form with the commission. The employee claim form can also be completed online, or the employee can submit a printed form. But in order to submit a printed form to the commission, the employee would have to request a form directly from the commission. And that email address to request that form is on the commission's website. So the Act does impose penalties for both employers and employees who violate the Act. So if an employer knowingly fails to classify an individual as an employee, the commission can assess a penalty of no more than $5,000 to that employer. That's kind of that first type of penalty. The second type of penalty is if an employer who is required to obtain workers' compensation fails to obtain a policy, the commission will order that employer to attend a type of hearing, and that hearing is called a show cause hearing. At this hearing, the employer will be required to show why it should not be, one, required to obtain workers' compensation for all of the employees' covered employees, two, found in violation of the requirements to obtain workers' compensation insurance, and three, why they should not be assessed a penalty for noncompliance with the requirements. So with those, having to show those three things, highly recommended that employers have an attorney if they are ordered to go to a show cause hearing. If the commission determines that the employer failed to insure all of their covered employees, the commission will order the employer to secure, maintain, and submit proof of insurance coverage within 30 days of the order. The employer can also be required to pay a fine up to $25,000 for losing essentially at the show cause hearing. Another potential monetary fine that an employer can face is for knowingly failing to report an accidental personal injury within the time frame required, and that fine can be up to $500. The primary penalty for employees who violate the act is a bar on filing a claim against their employer. So this means that if an employee fails to give the employer notice of a claim within the required time periods, the employee could be prohibited from receiving compensation under the act. And with that, because workers' compensation is considered an exclusive remedy, and uh, if the employee goes through that claim process, they now forfeit their right to file a claim in court. If they don't follow the time periods required, they would also be barred from filing a negligence action against their employer. So those are big penalties for both the employer and the employee for failing to meet the requirements of the act. So as promised, this is on the left-hand side is just a picture of the guide. And on the right-hand side is the QR code to the website with the guide on it. It has more details of everything we covered today, and a few sections that we didn't quite get to today. And we now have plenty of time for questions. I am going to just give a little disclaimer that really limit to general questions. If you have specific questions about an accident or claim scenario, you should reach out to your insurance agent, your insurance company, and or your attorney.